What's one thing your attorney can do to improve your chances if you have an 18-wheeler crash case? Hi, Kevin Runlett with Runlett Law Firm, continuing our series on 18-wheeler wrecks, things that you and your family should know if you're ever in one of these situations. So what is one thing that your attorney should do? There's a lot of things, but this is an important thing, and you need to be aware of it. What is one thing they can do to give you a leg up in your 18-wheeler case? Well, first of all, there's a body of rules, regulations, safety issues that have been codified, and federal laws that require certain things of truck drivers and trucking companies. Now, these are the Federal Motor Carrier Safety Regulations Administration. They've come up with these rules. These are laws that the truckers have to follow. They've got guidelines about how long they can drive without resting, how many breaks they have to take, all kinds of things with the mechanical issues with the truck. How often does it have to be taken to the shop to get evaluated? Maintenance records, driver's records of the driver, what checks did we put him through before we hired him on. There's lots of things that are rules and regulations that don't apply to regular car wrecks that apply to 18-wheeler wrecks. So the one thing your attorney should do is understand these regulations, first of all, be able to gather the information from the investigation of the crash, and determine whether one of these rules was broken. And why is this important? Well, it's very important because it creates a presumption in the case, which it's called negligence per se. What is negligence per se? Well, generally with a car wreck case or an 18-wheeler case, if you're the one that files the claim, then you have the burden of proof generally. So if we did not have negligence per se or the breaking of one of these rules, and we had a wreck and we filed the case, you're the person that was responsible, you and your attorney filed the case, the burden's on you. Meaning you have to prove by a preponderance of the evidence, if these are scales, you have to tip the scales in your favor, showing that the other person was truly at fault, and you have to present that evidence. Well, if a negligence per se issue comes up where you prove this truck driver drove for 12 hours straight without a break, was exhausted, was taking medication, if you prove one of those violations of the Federal Motor Carrier Regulations, the burden shifts. So it creates a presumption of negligence per se. It's just negligence as it is. And that burden then shifts to the trucking company, to the truck driver, to prove that they were not negligent. So you can see how that reduces the burden on the plaintiff or the person that filed the case and shifts it over to the defense. This can have a great impact on your case if you can prove this early on before you even file and get the defense ready and say, hey, look, we've got negligence per se here. It can greatly increase the negotiation leverage that you have to get your case settled for what it's actually worth. So I hope this helps. Let me know if you have any questions or comments. Leave them below. Would love it if you'd subscribe to us. It really helps. But we thank you for watching and hope you have a great day.